How do police officers get disciplined? Do you know there is what is called orderly proceedings? This is a proceeding where a police officer who has been found to have committed any disciplinary misbehavior he faces. It is found in what is called under Section 10 of the said regulations. Military officers are not disciplined by civil courts. Police officers have their own procedure. Vivian went to the National Police Service Commission and the Inspector General's office and brought the following manual on disciplinary processes of our police officer. It reads, Subordinate Disciplinary Committee. 1. Where a hearing is for purposes of undertaking discipline of an officer of the rank of a chief inspector and below. The commission shall constitute a subordinate disciplinary committee to inquire into and hear the disciplinary matter. The subordinate disciplinary committee shall consist A. A presiding officer, being an officer who is appointed as a presiding officer by the immediate commanding officer of the respective service, and shall be a rank not below the rank of an inspector and not of or below the rank of an accused officer. B. A presiding officer, being an officer who is appointed as a presiding officer by the immediate commanding officer of the respective service, and shall be a rank not below the rank of an inspector and not or below the rank of the accused officer. C. An officer appointed by the immediate commanding officer of the respective service to observe the proceedings, who shall not be a rank lower than the accused officer. 3. There shall be during the hearing of the subordinate disciplinary committee an officer prosecuting the offense, being an officer authorized to inquire into the offense against discipline, and shall be of a rank higher than the accused officer, but not of a rank higher than the presiding officer. 4. A police officer facing disciplinary action may be accompanied by another officer or his or her choice for assistance and support, provided that such an officer shall not be a senior rank higher than the presiding officer. 5. The subordinate disciplinary committee may decline the officer selected by the accused officer under paragraph 5 and shall give reasons for the refusal. However, the accused officer shall be granted an opportunity to select a different officer to assist him or her in the defense. 6. A police officer aggrieved by the subordinate disciplinary committee's decision may apply for appeal in the following sequence. A. At the county or formation or unit at the first instance. That is the appellate decision. B. To the respective Deputy Inspector General or to the Directorate of Criminal Investigations at the second instance. C. To the Inspector General in accordance with these regulations and the service standing orders at the third instance. Fourth, an appeal from the decision of the Inspector General shall lie with the Commission in accordance with these regulations and serving standing orders. Today, we have told you the procedure of how police are disciplined. In summary, it is called orderly proceedings. The proceedings are taken within the police lines where a senior police officer presides. Another senior police officer prosecutes. The accused police officer is allowed to come with any other colleague of his or hers. The proceedings proceed, and if a finding is found, it is forwarded to their bosses for disciplinary actions to be taken against them. Aggrieved. If a police officer is aggrieved, an appellate position, 4 layers. 1, You appeal to the county police commandant. That is where you appeal. Number B, if not satisfied, you appeal to the Deputy Inspector General. There are two Deputy Inspector Generals, the Deputy Inspector General of National Police Service or Administration Police. Free to the Inspector General. If you are unsatisfied, you appeal to the Inspector General. And lastly, if the Inspector General does not give you a favorable appeal, you appeal to the Commission. If the Commission does not hear your position, you now move to the High Court. Today, we have one case here where somebody went to the High Court. This is LRC petition number E065 of 2024. That is Andrew Chalo Mwanza versus the National Police Service Commission, Inspector General of Police, the Directorate of Criminal Investigation, and the Attorney General. What was the allegations? The petitioner averts that he worked for the service without blemish until 4th January 2021, when while out of his faculties due to influence, he had a rifle discharge at Huruma Shopping Center, where several rounds were fired out of his G3 rifle, which was lawfully assigned to him, but unfortunately no one was injured. This officer was drunk, and he admits he was drunk. But while he was drunk, he had a G3 gun. He fired several bullets accidentally. This was a serious issue, and he was dismissed. Then the police, when they charged him, in paragraph 4, they say the platoon commander called him, and while he drank, he allegedly uttered words that he wanted to kill his then girlfriend. Pronouncements which were unfortunate and not intended, as he had never had any altercation with his then girlfriend and now wife. So because he was drunk, he was called, he said, "Me, I'm going to shoot my wife." He was arrested, he was disarmed, then he was sacked. He went through the court, the orderly proceedings. He appealed to the county police commander, he lost. He appealed to the Inspector General, he lost. He appealed to the commission, he lost. This case went before the judge. And what did the judge say? In paragraph 71, the petitioner was apparently subjected to the subordinate disciplinary committee. The respondents aver that they conducted the proceedings under the service orderly room's standing orders. Orderly room proceedings are provided for in Chapter 30 of the Service Standing Orders. Section 17 of the PSC Discipline Regulation provide how the disciplinary proceedings may be conducted. Subsection 3 states that in all disciplinary proceedings, the accused officer shall be notified of the offense he is charged of and shall be given at least 3 calendar days within which to show cause why disciplinary action should not be taken. The petitioner has averred that he was never issued with any notice to show cause. The police have averred that they followed the process. On the same day, the disciplinary sat and heard his case, but there was no notice of the hearing to take place. There are no proceedings exhibited of the hearing of this day. Having analyzed the proceedings, the petitioner was subject to, "It is in my finding that the proceedings were conducted unprocedurally. The offense is said to have been committed on 4th January 2021, and on 5th January 2021, he was subjected to disciplinary proceedings and a decision made against him without any notice and no written statement given by the presiding officer as to why he was being subjected to a hurriedly convened process. In view of the provision of Section 45(2) of the Employment Act 2007, it then follows that the petitioner was not fairly and legally dismissed from the service. So the judge ordered that he be returned to work. What is the law here? Whether it is the police force, due process, the rule of law, whether you are drunk, you must be given a notice sufficient to come to defend yourself. We know very many police officers have been dismissed summarily without the due process. A lot of intimidation and fear that the police have no rights. The Employment Act 2007 protects also police officers. Remember, the police are there to protect us, but they think there is no law that can protect them. The law is there to protect. They are our good police officers. You now know that the law protects anybody who has been unfairly terminated. The framing up that this police officer who was drunk, that he wanted to shoot his wife, was nothing that was proved before the Employment and Labor Court. Wakili Dan Omari, a pleasure always. Thank you.